All right. Good afternoon, everybody. I'm going to let everyone just get a minute to get logged in so we can get started. But we have an amazing webinar planned for you today. I am extremely excited about this because I've got my dear friend Mark back with us and I've got Sam with us, and you guys are going to learn so much. I highly encourage you to take down some notes, but keep in mind that I will email you a copy of Mark's slides as well. And then in it is a lot of information, the email that I just sent you, about his brand new book that just came out. So I definitely want you to check that out. And then we're going to dive into a lot of that during this discussion as well today. And then I want you guys to ask questions, but just keep in mind that the majority of your questions will be saved towards the end of the webinar because I want to make sure that we get a chance to get through everything. And then keep in mind that this will probably turn into about 2 hours because we want to make sure we have plenty of time to answer your questions towards the end. But get ready to learn a lot. And then later, you're going to meet my amazing partners at HMR, OnPoint, Fox AE, as well as Emotion Track. And then you'll get a chance to hear all the great things that they do. So I'm going to get started right now because we are going to be covering a lot today. First, I wanted to introduce you guys to my friend Sam, who's an incredible trial lawyer. He works with Satch Oliver out of the Rogers, Arkansas firm. And if you guys know or notice, just a couple weeks ago, we did a wonderful webinar with Sam, and I'm going to be posting that back on, I guess, our YouTube channel, hopefully by the next day or so. So you guys will get a chance to see all the things that they do. And then also you'll hear about everything that he talked about during his first jury trial, which is really incredible. So give me 1 second. I'm going to pull this up real quick because I want to make sure that I do a great introduction for Sam so you guys can hear about all the things that he has accomplished so far. He, as I said, is from the beautiful countryside of Calico Rock, Arkansas, which is situated along the White River, and it's not far from Norfolk Lake. And after he graduated high school in 2012, he pursued his bachelor's degree in political science from the University of Arkansas, and therefore also received his law degree and that was actually in political science, which is pretty cool, from the University of Arkansas. And he received his law degree from the University of Arkansas, William H. Bowen School of Law in Little Rock. And he has been with the Oliver Law Firm since he graduated from law school in 2019. He also served as president of the Benton County Bar Association for 2 consecutive years from 2022 to 2024. And he's a member of the Arkansas Bar Association, as well as the Arkansas Trial Lawyers Association, which is love their staff. They're amazing over there. He's also a member of the American Association for Justice, as well as the Academy of Truck Accident Attorneys. And he's also an officer in the Arkansas Bar of Association's Young Lawyers section. Now, since Sam joined the practice and he started working with the Olive Law Firm, he's had the privilege of working on and resolving a number of multi-million-dollar cases, and most of those involve a lot of wrongful death as well as losses of loved ones. And however, one of Sam's favorite parts of his job is meeting his clients and being able to connect with them on a level that creates lifelong trust as well as an unbreakable bond. So we are very excited to have Sam with us today, and I can't wait for you guys to hear more about Mark and what he's going to teach you. So Sam, I'm going to go ahead and hand it over to you. You guys have a great webinar.
Thank you, Ginger. Mark, I apologize. Ginger's introduction of me is going to be much better than my introduction of you, but please forgive me. Guys, I can't explain to you how excited I am other than tell you that I am excited about this presentation. If you haven't heard of Mark, which I'm sure that all of you likely have, he is up in Minnesota. He is what I would say is one of the greatest trial lawyers of all time, and that's what my boss, Satch Oliver, says too. He's worked for 44 plus years doing this type of work, and in the recent years, his practice focuses primarily on sex abuse and nursing home abuse cases. And you just got an email about a book, his newest book that's released. It's called Litigation Obstruction, Breaking Through. And that's what he's going to talk about today, a lot of the information that's in that. So other than his extensive qualifications and practice, I can tell you that the presentations that I've seen, Mark in, he is also an excellent harmonica player. He says he salsa dances. I have not seen that yet. And he is also an international cyclist, as I would say. He may say it differently, but he loves cycling. And last thing I want to say is that, Mark, I'm just sorry that the good Lord covered up your brilliant mind with all that hair. Not everyone can be as lucky as me. So kick it off.
Well, thank you. That's really nice of you, and it's just a privilege to talk to everyone here. As I'm setting up my share screen, we are Zooming today from the shores of Lake Superior, which is 10% of the fresh water on Earth. And so I'm up at my cottage up on the lake, so things are pretty casual, yeah, but quite beautiful. I'd love to talk to you about the lake, but we don't have a lot of time to cover a 2-day seminar in an hour or so. I've hated bullies my whole life when I was a kid, and we have a profession that's filled with them, and it doesn't have to be that way. This whole talk about, who we can beat up and how strong we can be, it's just kind of nuts. We're professionals and the rules work. And if you really know the rules, you can let your opponents step all over themselves, and you're going to get the evidence, and you're going to win the case big, because evidence is the single most important thing at trial. So let's just talk about this a little bit now. What is it that we actually see in this world of litigation?
Normally, we do these presentations in DRI venues and more private defense-oriented venues. I am actually sort of reluctant to give away all strategies, but in the interest of fair play, I want to discuss some of them. I can't tell you how much I would encourage you defense attorneys to not give over any documents willingly, other than the chart.
I don't think you have to tell them that. I mean,
No, people give over stuff not realizing it. I mean, we try to fight everything: incident reports, surveys, anything, logs saying other people's names are on the log. You have no right to them. Anything, because we find that 50% of the time, plaintiff's attorneys that ask for something, we give them an excuse why we can't give it to them because it's privileged or this or that. They never make a motion, and they may never get it, because it's the compilation of the problems, the compilation of the abuses, the compilation of the survey gigs. They're the ones that set the scene for these hits in these cases, in these other jurisdictions. So you have to streamline, deny documents.
Actually teach that stuff. And I really disagree with everything he said. But one thing I disagree with more than anything is when he said 50% of the time plaintiff's lawyers won't bring a motion. That's nonsense. 90% of the time plaintiff's lawyers won't bring the motion. For a lot of reasons, and we're going to talk about how we can do this so that their obstruction doesn't bog down your practice. Whoops. Because we know that obstruction is ahead. I don't care if it's the first case you've ever handled, or you've handled 1,000 cases, or you don't even know that obstruction is occurring. It's always there. And so if you want to get the evidence, you've got to keep a focus on what it is you want and what the potential motion is going to be, because it's important to keep an eye on your requests, starting with the lens that the court is looking at through, because we can have all the I would argues we want, but in the end, what is it that the judge is going to be doing, and how do we persuade the judge? And I know there's going to be a lot of you out there, because I hear it every time I talk about this, say, yeah, but in our jurisdiction, judges hate discovery motions. And that might be true, but the question is why? And what I've learned as we've developed this process here, it's not so much they hate the discovery motions, but they hate the conduct of these lawyers coming in and just kind of pissing all over each other. And so if you bear with me, I will share with you that in this particular process I'm talking about, courts take a completely different attitude. And it's not just because I've got gray hair. It's because we take an approach where the judges say, these are professionals. And we had one about a month ago where we brought the motion, and after we'd gone through this process I'm going to talk about, the court said at the outset, it is such a privilege and a pleasure to see lawyers who are acting professionally. It's going to be my honor to resolve these remaining questions you have. And that's a true story. So just keep that in mind as we go through this. So what is it that the judge is going to have to decide? Everything I'm talking about is on the federal rules, but I'll tap into the state rules also. The judge will always have to decide, is this discovery request relevant? Is it proportional in federal cases or states that follow proportionality, or the cases that don't? Is it overburdensome? Who's got the burden of convincing the judge, and what do they have to convince them of? And then ultimately, what are these objections valid? So we start with the scope of discovery. That's Rule 26B1 in the federal rules. And it says parties may obtain discovery regarding non-privileged matter that is relevant to a party's claim and defense and proportional to the needs of the case. That's the federal rule as of 2015. And so if we want to win our motions, regardless of whether we're in state or federal court, we're going to want to have requests that are relevant and proportional. So let's zero in on relevance. That's really the first legal question the judge is going to ask. What is relevant? The stuff that they're looking for, does it have anything to do with this case? And the cases, and this is a 2021 11th Circuit case, talks about relevance in the context of discoveries to be broadly construed. And it encompasses any matter that bears on or could lead to any matter that could bear on any issue in the case. Well, issue is the operative term, okay? In the federal rules and the cases that follow, or the states that follow the federal rules, an issue is something that relates to the claim or the defense that has been pled. That's the new rule. And so the real question you have to ask yourself, because you're going to have to tell the judge, why do you need it? Why is it that we need this? Not that, well, maybe in a small percentage of the cases, there's an outside chance that I'm going to catch them lying. That doesn't hit the standard, even though that's what I was taught 45 years ago. What is it that I want, and why do I need it? You say, yeah, cause I don't go to federal court. I'm in Arkansas. It's, well, Appendix B of my new book, Litigation Obstruction, lays out what the relevance rules are in every state. And what we know is under the new federal rule in the states that follow it, issues equal claims or defenses. But under the old rule, which also talks about issues go to the subject matter of the case, which is broader. That's anything that could lead to the claim or defense. So some states go with the claims and defense rule, other states go with the subject matter. We don't have time to go through a state-by-state analysis. This map is in the book, the charts are in the book, and I also go through every state and compare the state rule to the federal rule. But as you can see, it's split about 50-50. The red states here are the ones that say to be relevant, it has to relate to the claim or defense. And the states that are in blue, it has to be relevant to the subject matter. Those of you from New York know New York has no rules comparable to the federal rules. Your state and the analysis of it will be laid out in Appendix B of litigation obstruction. So that takes us to proportionality, which is really just a codification of the overburdensome standard under Rule 37. And I covered this in huge detail in Chapter 3 of the book because, you know, it's relatively new. It's 9 years out, but in our world, that's relatively new. And so we're filled in this whole thing where, you know, we've got lawyers who go, I would argue. I don't care what a lawyer will argue. I care what the courts have said. And I think one of the things we've learned over time is we really don't have that many fresh and creative legal thoughts. It's almost always been covered somewhere. And that's why it took 4.5 years just to do the research on the book, is to get the 2,000 cases that we have in there for every state. So when 26B1 was amended in 2015, they codified this whole history of burdensomeness and said that if you can get relevant information as long as it's proportional to the needs of the case. And they gave us 6 factors without a whole lot of guidance. And it said importance of the issue, the amount in controversy, relative access to relevant information, parties' resources, the importance of resolving issues, and burden versus benefit. And then they say, but no one of these factors are controlling, and any one of these factors might be the important one. And so I go on for about 40 pages about going through each one of these factors and how it's important. But for the purposes of this talk, I'm going to go through the decision tree that was a function of putting all the cases we could find up on the whiteboard and trying to figure out how do they relate to each other. So this is something that has only been shown once or twice since the book has come out. It wasn't published anywhere. It'll be everywhere now that AI will be sweeping it up. But here's the analysis you have to go through for discoverability. And this isn't something you could use with the courts or with your adversary, and frankly, most importantly, with yourself as you're making discovery requests. So the first question is it relevant? Is what I'm asking for, does it have anything to do with either the claims and defenses or the subject matter, depending on what rule you're under? And so if the answer is no, it's not relevant, you just want it because you think it'd be cool to have it and bloody their nose, you're not going to get it. But if it is relevant, then the question becomes, is it privileged? Now, this isn't whether they claim it's privileged, but they claim everything is privileged. The question is it legitimately privileged? And, you know, that's a 1-hour talk on its own. But as you're analyzing privilege, if it is privileged information, then you don't get it under any circumstances. But if it's not, now is when we go into the proportionality factors. Because we got relevant information, but we can only get it if it's proportional to the needs of the case. And what we've learned from all of these cases is the very first factor you look at is is this a matter of public importance? How big a deal is this? Because it's not always money. Because remember, the defense lawyers will always say, well, this isn't that big a case. Well, voting rights, there's no money involved. That's a pretty big deal. Harassment claims, human trafficking, those aren't money cases, but they're profoundly important. And if you read the book, there's a case called Gomez that says wrongful death is enormously important, not because of the money that someone's asking for, but to identify why the person died, to make sure it doesn't happen again. So it's a matter of public importance. So if the answer is yes, it's a matter of public importance, then the next question to ask is, does this discovery request go to a central issue in the case? If it does, 99 times out of 100, you're going to get this. And the only reason I say 99 instead of 100% is I've learned that nothing's 100%. But if it doesn't go to a central issue in the case, but it's something that's relevant to the case, then that's when we get into the money. What is the amount in controversy? And so then we go right back to, regardless of the amount of the money, are we going to the key issue, the central issue of the case? Yes, now it's highly probable that you're going to get it, even if it's expensive. But if it doesn't go to a central issue in the case, now we get into the question, is it calculated to lead to admissible evidence? And if the answer is no, you're probably not going to get it. But if the answer is yes, now we get into the balancing of the remaining factors. How important is this information for resolving the case? Who's got it, the burden of coming up with it? Who's got access to it? And what are the relative resources? And now those factors are balanced. And the question becomes, is the benefit of getting this information for this lawsuit outweighed by the cost or the burden of getting it? If the burden, if it's really burdensome and it's not that beneficial, then you're not going to get it. But if it's yes, then you should get it. But this is the analysis you go through as you're making requests to decide, do I want this or not? And it's that whole chart is in the book. It doesn't have the animations, but the chart is in there and it's in chapter 3. And so the question is, does your state have proportionality? And it's interesting that the proportionality rule does not necessarily follow the relevance rule. A lot of states who have the new relevance rules don't have proportionality. And then there are states who follow by the old rule of subject matter that have adopted the proportionality rule. So I've kind of highlighted it. The reds here are the ones that have proportionality. The two pinks are the ones it's not as a matter of course, but a motion for good cause. And the blues are the ones that, and we're calling Arkansas a blue state here, is that even though there's a picture of John Kennedy on the wall, it's the proportionality rules. You got to know what it is for your state. But, you know, regardless if your state follows a proportionality rule or it doesn't, the courts go to the burdensome rule. And you can use that same analysis when they say this is overburdensome or it isn't. Because under Rule 37, they can move for a protective order for something being overburdensome. So that's the concept of relevance and proportionality. But I think this would be a real good break time to bring our partners in to share with us how they can help us in our lawsuits. So I think this is you. Do I have to unshare the screen now?
Ginger, are you? Yeah, Mark, I think there we go. Let's see. Ginger, who's our first sponsor? All right. Just give us a second here, guys.
Should I just keep moving and bring them in, or?
Nope, this is perfect, guys. Sorry, I'm here. Okay, I'm gonna bring in, first of all, let's see who we're gonna bring in. I'm gonna bring in Aaron with Emotion Track. They are doing some incredible work over there. And I know you guys, if you've been watching some of our webinars recently, then you've had a chance to hear about some of the incredible AI technology that they're using in jury trials. And Aaron is here. So good to see you today, Aaron.
Great to see you, Ginger, as always. Nice to meet you, Sam. Nice to meet you, Mark.
Absolutely. Well, we're excited to hear about some of the great things that you're doing over there. I know John Romano is working with you guys on a lot of cases, and he is very happy with the results that he's getting. So if you could share some of the new things that you guys are doing with everybody.
Absolutely. I'm so distracted by that painting behind Sam. It's just very powerful. Now, I wonder where I can get a copy of that one. That's beautiful.
Thank you. It's the White River in Calico Rock, Arkansas.
It's gorgeous. All right, let me share my screen and share a little bit about what we do for all those who don't know. So we have created an AI solution that understands emotions. And to simplify it, we've created a solution that is sort of a hybrid between a focus group and a mock jury. And it's all done remotely. And the way it works is lawyers are all about telling their stories. And so we record an attorney doing a narrative about their case. Sometimes they'll have an associate or another attorney representing the opposing counsel and tell a story for about 5 to 10 minutes. Then ask for any demonstratives, any exhibits, and we'll edit that into a final reel or like a movie trailer. That gets delivered to a panel audience of at least 100 people, so it's quantitative data. And we get real-time insights on how people are feeling as they're watching the story about their case. Once they finish watching the case, we ask them a series of survey questions, and those survey questions are crafted, which we work with the attorney on all of this. They're crafted based on the objectives of what the attorney is trying to accomplish for their case. And then we do a report and debrief in depth so they understand the different strategies on how to approach, whether it be a settlement, a mediation, or a trial. I also want to share a little bit of the product as I did last time. Can you see the dashboard here? Everybody, can you see the dashboard?
Yeah, that looks
Sam,
great.
Mark? Okay. So, Mark, I understand that you do nursing home cases. And this was a nursing home case. So this is a video that we worked with the attorney, and by the way, it's a very, very light lift. We can do this in 15 to 30 minutes of your time. Basically, we'll get you on a Zoom call, we'll act as the director, you'll act as the actor, and we'll just record you, and you'll start saying, hey, my name is so-and-so, and I represent the plaintiff in this case, and this was what happened, and go through all it. Basically a mini opening. I'm going to play a little bit of this video.
On June 19, 2021, an 85-year-old woman became a resident patient of a nursing home known as Bella's Care Home. On her first night in this care home, the victim suffered brutal injuries to her head, both sides of her face, the front of her neck, and her right shoulder. Her head injuries caused intracranial bleeding that would end her life 12 days later on July 1, 2021. The victim suffered these injuries as a direct result of the abuse and neglect of her nursing home caregivers. The nursing home would now have us believe that the victim suffered all of these injuries as the result of a single unwitnessed fall in her nursing home bedroom. The evidence clearly shows that the injuries couldn't have been sustained from a fall alone, and regardless, there is plenty of other neglect and abuse.
I'm going to pause here because I can go through the rest of the story, and there's more demonstratives and exhibits, and we show some family pictures to humanize. the individual and the individual holding her pet and so forth. But what I show you is this little EKG map. And this represents how people are reacting emotionally moment by moment as they're watching. These are subconscious responses using microfacial expressions that we're picking up multiple muscles in their face so we can determine whether they're happy, sad, or angry. And then we compound that into different sentiments, like this is called our angst map. And this is telling us how people are feeling as they're watching. And you can see blue represents male and pink represents female. And there's different trajectories. And if I played it back and you could watch it, the line as it plays back, it tells us how the audience is reacting to the story and where it's weak and where it's strong. But it's also driving them at the end, where we call our peak end rule at the end, to defining on how they might vote if they were a juror in this case. And so we also asked them a post-video survey question of, for example, based on the facts, what would you award the individual? And you can see here how the audience, male, female, awarded based on multiple choice selections that we provide them. Now, there was a settlement on this case, and it was disclosed, and it was an acceptable settlement. But let's say you had a low offer, or you were trying to negotiate mediation and you weren't getting there, but you could see that a big percentage of the audience was voting for a high number. That might move you to say, you know what, I'm going to litigate this case. So that's a little bit about Emotion Track today. We've only been doing this for a little less than 3 years. Our attorneys all over the country have already achieved over $500 million in settlements and verdicts using our tool. And we invite all of you out there to just give us a call, spend 15 minutes with us. We actually we send you a nice little gift for spending 15 minutes with us afterwards. But more importantly, let us help you. We always say at Emotion Track, we help lawyers help people. That's what we do. So let us get you that research, that insights, which insurance carriers and opposing counsel are starting to say, oh, you're investing time and money to get research on the case. You better listen, before we say we're not going to counter a decent amount offer. So thank you, Ginger, and thank you, everybody.
Yeah, and I just wanted to mention too, Aaron, that you guys are working with these amazing attorneys like Keith Mitnick, Ilya Lerma, Dino Colombo, and many more, and they're getting these huge multi-million-dollar verdicts. And the type of software that you guys are doing is really helping in many ways. So I hope everybody watching will at least call Aaron, check that out, look at their website. That's the main thing. And you can watch some really cool videos on there as well.
Yeah, thanks, Ginger. And, by the way, we also worked, I don't know if everybody knows Rex Paris out on the West Coast, but he came to us to test the case. He thought it was worth $80 million. Our data showed it was worth well over $100 million. And he ended up getting a verdict of $120 million. And by the way, we're not costly. So just give us a call, give me a ring. I'll put my information in the chat.
Okay, perfect. All right, Aaron, thank you so much for stopping by today, and we will see you again very soon, okay?
Thank you.
All right, and then I see my dear friend Patrick is with us with On Point Legal Nurse Consulting. He is fresh off of their very first live seminar from Philadelphia yesterday, and I'm so proud of you guys for the work that you guys are doing for so many of nurses, doctors, attorneys. And Patrick, it is an honor to have you with us.
Thank you very much. I appreciate it as always, Ginger. Very nice to meet you, Mark. Nice to see you, Sam. The conference went very well. Jessica Latour from the Romano group, of course. She was fantastic. She did a great job after, I think, a 26-hour train ride. So she really was fantastic. It was a great day. It was at the Barnes Foundation, which is a beautiful museum. So we all had a wonderful time. And I hear we're bringing it to Florida. Hopefully in the next couple months. So we'll be able to bring it down there. But anyway, my name is Patrick Stonich. I'm one of the program directors over at On Point Legal Nurse Consulting. I work side by side with Ingrid Sidorov, who's a master's prepared gerontology nurse, who's been practicing for over 40 years. I've been a nurse for about 20 years. Our department strictly is focusing on nursing home support litigation. So we do nursing home cases for abuse, neglect, wrongful death. My background is in home health and hospice and the long-term care world. So skilled nursing facilities, personal care homes, and assisted living facilities. So we really focus a lot on those cases in our department. Our other departments, of course, are run by Dawn, and she does all of the work for our consultants. So the behind the scenes work, which includes merit screen, medical chronologies, pain and suffering reports, and life care planning reports. Under Ingrid and I, we focus, like I said, on the skilled nursing facility side. So we have a fantastic group of nurses, director of nursing, assistant director of nursing, and we have many medical professionals that are available to help review cases, provide expert reports. We've got all of our experts, most of them we know very well personally. Every expert that we send over or place on a case has been vetted. So there's no mystery when it's too late down the road. So we know exactly who the experts are. Again, I love being a nurse. I've been a nurse for a while. I love the legal side. It still enables us to not continue to advocate, but for very different reasons. The nursing reports that we produce are fantastic reports. It's great to get the nursing perspective. We like to also have interviews with our clients or your clients, and be able to really tell the story of kind of what has happened to these families or to the patients and any sort of injuries. Nursing home abuse and neglect is way too rampant in our country, and we try and support you guys from intake to trial to support these families in these cases. So if you need anything, as a typical nurse, we love to talk and teach. We're there to answer questions quickly, so we can get you, to explain anything that needs to be explained. And I'll put my information in the chat, and make sure you reach out, and hopefully we can help you guys out.
That sounds fantastic. Thank you so much, Patrick.
You're
And then
welcome.
also, just a quick reminder, John Romano raves about you guys' pain and suffering reports. He's like,
He does.
"They're
He's
the
our big,
best."
he's our
Yeah,
big supporter of the pain and suffering reports,
he
but they're
really is.
fantastic reports. Of course, they're non-economic damage reports. I do many of the pain and suffering reports. It's very nice to be able to talk with the clients, and get just a different experience and a different perspective, that John always says. He always says you should have nurses on every one of your cases. So of course, I strongly agree with Mr. Romano on that.
Well, great job. Thank you again so much, Patrick.
I'll
Sounds
see
like
you.
you and Mark, you guys need to link up at some point too.
Mark, if you need anything, Ingrid says hi, by the way.
Oh,
She sent her best.
wonderful.
Yeah.
You're spot on that there's just way too much abuse and neglect in our country. It's horrifying.
It's horrifying. And every day, I mean, we get cases nonstop, and each case, it takes my breath away. I thought I saw everything working in this world. Every day, I'm just shocked.
I'm with you on that. And that's what we've learned, is they're not about just the clients, but about the horrible behavior that
Yes,
does these things to our clients.
I
So we
agree.
can talk about that for hours, but we don't
can.
have that time.
Next webinar, Mark,
Hey,
we'll
great,
definitely do
great
it.
things. We can do one. So anyway, got great
you.
partners here, Ginger. But let's get back on board here, because we got a lot of ground to cover. And so
Hey, Mark, you were talking about privileges. We can answer this now or later, your call, but we have a question about busting through the work product privilege objections from defense lawyers. How do we get through that?
the question was what?
Well, do you have any tips for busting through dubious work product privileges where it's obvious that a defendant is really just trying to shield bad documents, saying that they were generated in anticipation of litigation?
Well, anticipation of litigation is, of course, volumes there on its own. I will be doing a little thing in the future here on this presentation about using 30B6 to neutralize their objections. Ginger's has got some other talks I've done on 30B6, and facts are never privileged. They're just not. Attorney's work product may or may not be privileged, but just because they call it work product doesn't make it so. And if you'll just hang with me for half a dozen slides here, we'll talk about some law on that, if that's okay.
You bet.
All right. So, because here's what we get to. Who's got the burden? If someone says it's privileged, or it's irrelevant, or it's work product, who's got the burden of establishing that? Or on any objection, to our discovery? Well, the initial burden of relevance comes on us. We have the burden of making a prima facie evidence, or a prima facie showing that our request is relevant. That's why we have to understand the law of relevance. But it's a pretty easy burden. We have to show how it's linked. And once we show that it is relevant, then the burden shifts to them to prove whatever the objection is, be it work product or privilege, disproportional. And the burden is on them. They have the burden, including proving lack of relevancy once we do that prima facie showing. St. Paul Reinsurance is a case by Judge Mark Bennett from 2000 that's still being cited all over the country. And it lays out a lot of these elements we're going to talk about. But the interesting thing and the important thing to remember, including this work product objections have been raised, they've got to show, they've got to prove with evidence or affidavits that this is work product. They can't just call it work product. They got to prove it. They got to show it. And one of the things that we'll be talking about in the second half of this talk is they just like to say stuff. They'll throw everything, they'll throw all the droppings on the wall and see what's going to stick. And it doesn't work that way. The burden's on them. Now, I'm going to caution you that affidavits are oftentimes false. Shouldn't be saying that, but I find it all the time, because some lawyer who's lost sight of their ethical obligations, which I talk about in chapter 1 of the book, just create these affidavits for their clients to sign, and then they sign them without even reading them. And so we have to, even though the burden's on them, we got to be cognizant of the fact that some of these affidavits may be coming. And so we're going to talk about, in a case involving an institution, how you use 30b-6 to neutralize that. And that's going to be in about half an hour, if you can bear with me. So the burden's on them to prove it. But then the judge is going to have to ask, he or she, they're going to have to say, are these objections valid? These objections that are being thrown out here, yeah, they've got the burden of the proof, but is this a legitimate objection to a relevant request? And, they all comes up. Work product, overbag, vague, irrelevant, confidential, not proportional, not calculated. They just throw it. What's your name? Work product. They told me, they told the lawyer the name, so it's not work product. It's just nonsense. So we have to understand what the rules of objections are. And we start with the premise that the objection has to be specific. Not a real high-level legal research, it's in the rule. Grounds for objections must be stated with specificity. Work product, objection work product, that's not specificity. Overburdensome, that's not specificity. My cough drop is choking me up here. There's got to be some evidence for it, and it's got to be timely. And this is an important thing to remember. How many times do you have written discovery and they say the check's in the mail? I'm getting it to you. It's coming. We're working on it, Sammy. We're working on it, buddy. And it just time and time and time. And standing in the shower thinking about responding to your discovery doesn't qualify as working on it. And the rule 33b-4 is clear. The grounds for objecting to an interrogatory must be stated with specificity Any ground not stated in a timely objection is waived unless the court for good cause excuses the failure. I'm going to Europe, or I forgot about it, or I'm busy. That's not good cause. I did see a case where the lawyer said, the day before I was going to answer, my wife went into labor and I was in the hospital, and the court gave him a bye on that one. And that's valid. But saying I'm too busy to handle the case is not valid, because ethically a lawyer is not supposed to take a case if they don't have time to work on it. So untimely objections are waived, okay? Kosieradski versus Discovery Card Services, great case, lays out a lot of these rules. But it's important to remember that even work product is waived if it's not raised in a timely fashion. There are some cases that allow them to waive, that say privilege is waived. I'm not sure a lawyer can waive a client's privilege, but they can waive their work product. And that's if they don't make the objection in 30 days. And Kosieradski said that even though the rule for timeliness is the interrogatory rule that talks about it, Kosieradski, in a lot of cases that follow it, say, yeah, but this applies to requests for production also. Non-specific, untimely objections are waived. So either it's an objection that's made, but it's not specific and it isn't supported the way it's supposed to be, or just not made at all. If it's not made within 30 days, it is waived unless the court thinks there's good cause. So here comes a practice pointer. Oftentimes people will say, can I have an extension to answer this discovery? And the court wants us to be professional and work together and not play this bully gotcha game. And I think it's appropriate to grant someone an objection for a substantive answer if it's going to take them some time to give me a legitimate answer. But an indefinite extension is just the same thing as you don't have to answer it. So if they wanted an extension, say, I'm happy to work with you on it. Let's establish a specific date when you're going to tell me you're going to answer it. Is that 7 days out? Is it 30 days out? Is it 2 weeks out? You know, don't be a jerk. If they say, I need 6 months, you say, you better explain to us why you need 6 months. Well, I got a trial every week for the 6 months. Chapter 1 of my book the ethics chapter will explain it's unethical to take a case if a lawyer doesn't have time to work on it. So the answer, if they say they want 6 months, is say, we better tell the judge that you're too busy to handle this case. And they usually back down. But this is just for substantive stuff. How about objections? I don't think you should ever grant an extension for an objection, because you don't need 3 months or a month or an extra week to decide whether the question is objectionable or not. So I would encourage you never to grant an extension for the objections and say, okay, we'll extend the deadline for a substantive answer of 21 days, but we're not waiving, or we're not extending the time for you to object because you don't need to do anything. So if there's a legitimate objection, then that needs to be served within the time frame of the rules, which is 30 days. Because if they object, that gives you time to start your meet and confer process to work through the objection, as opposed to kicking that can down the road another month. But you get all these objections, and these are the kinds of things you can talk about. There's no need to get 30 days. Blanket objections at the beginning. You know what I'm talking about, the 7 paragraphs before the answer. to the extent that any of these questions may or may not, violate work product or privilege or hearsay or relevance or burdensome, we reserve the right for these objections. And they're going to apply to everything. And courts have universally rejected these general objections, saying they're not specific. They don't say what's wrong with any given question, and therefore they're waived. That boilerplate thing at the beginning is a non-thing, and it doesn't mean anything. I think it's worthy, as we'll talk about later, to point out Fridlin or the cases in your jurisdiction and say, we're asking you to withdraw this so we don't have to litigate this. But then there's boilerplate objections. You ever heard of those, Sam? Every single question, vague, ambiguous, overbroad, seeks information protected by privilege, and work product is not proportional to the needs of the case, not reasonably calculated to lead to admissible evidence. Marston's habit violates the rule against perpetuities. I think it's a stupid question, and I'm not going to answer it. But subject to and not waiving these objections, we're going to give you everything that doesn't hurt us. That sound familiar?
Yeah, it's like their computer types it out to every response.
Every single response, no matter what the question is, that's a boilerplate objection. And this is probably the most important part of the talk coming up. Ligura versus Griffith, once again, Judge Bennett says a boilerplate objection is the same thing as not making an objection at all. And I want everyone to write this one down. Mancia versus Mayflower, 253 FRD 354, on page 359. Judge Grimm at the District of Maryland said, boilerplate objections are prima facie evidence of a Rule 26G violation. Prima facie evidence. And you say, but if you and folks out there are like me 5 years ago, after 40 years of practicing law, saying, what was 26G? What are you talking about? 26G is the signature rule. When we make a discovery request, or if we are answering discovery, we have to sign it. Say, fine, what's the big deal about that? Well, because if that certification isn't valid, the court must, not may, not maybe, not perhaps, but must impose sanctions on the signer. And 26G requires that in a discovery response, for the lawyer to say, and I've got a whole chapter on this, chapter 4, requires the lawyer to make sure that their client understands what the request is, explains to them what is required of them, and then the lawyer has to make sure that the client has done an adequate search. Then the lawyer who signs this discovery response has to certify that everything that is being produced, and that if there is an objection, it's grounded in law and fact. And if it's a boilerplate objection that throws everything out, then under Mancia, which is followed all over the country, the footnote in chapter 4 literally goes jurisdiction by jurisdiction, citing the cases for your states. It requires the court to sanction the lawyer who's doing a boilerplate. Look at him go for that book. I can see the smile on his face. I'm going for this, man. Now what the sanction is up to the court. It may just be an admonishment. It may be money, but it's a great tool in your meet and confer process to let the lawyer know that they can't just throw everything out. And they say, we're doing a CYA here. Well, no, there's no such thing as a CYA. What we have here is, as a professional advocate, there's a responsibility to make sure discovery is responded to. These aren't just hoops to jump through. Discovery is real, and lawyers and their clients are supposed to respond. But so let's say they respond. Ever notice the qualified response? Objection and without waiving? Probably on every one of your requests, Sam. Every single request, what's your name? Objection, but without waiving, I'll tell you. Who are the witnesses to this case? Objection, but without waiving. Well, what that means is we're objecting, and we're going to give you everything that doesn't hurt us. That's what that means. And in my 30B6 book, I talk about it pretty extensively. And in the new book, there's a whole section on it. This kind of answer, agreeing to respond and produce information that the lawyer independently tries to rule on their own objections and give you stuff without waiving, does nothing more than obscure the information that's being requested. And not only do you as a requesting lawyer not know if it's complete, the court doesn't either. That's why they have to have specific objections. Objection without waiving is impermissible. Courts everywhere, all over the country, have ruled that way, and they're cited in the footnotes of the book. But the case from the Northern District of Florida, Network Tallahassee, sums it up better than anyone I've ever seen. What the court in this 2-page opinion, so even Satch would be willing to read that, an unscrupulous lawyer, this is a quote, an unscrupulous attorney could withhold properly discoverable information, a smoking gun document, and assert later that they did nothing dishonest because they objected. So Network Tallahassee has said it's presumptively sanctionable to do objection without waiving. But then the Rules Committee on document requests said, you know what, we got to clear this up. So in 34B2C, the rule was amended to say an objection must state whether any responsive materials are being withheld on the basis of that objection. So you can't object without waive. You have to say, we're objecting, and here's what's being withheld, as opposed to leave everyone hanging. And the Rules Committee in 2015 said, quote, this amendment should end the confusion that frequently arises when a producing party states several objections, still produces information, leaving the requesting party uncertain whether relevant information is being withheld. They said you can't do it anymore. So here's what I saw following 2015. Objection, but nothing's being withheld. And I suspect many of you have seen that. Well, Heller versus City of Dallas put an end to that. They said it is improper to assert a boilerplate objection to discovery when there are no documents responsive to the request. Why do you need to object if there's nothing to object to? So if no responsive documents or tangible things exist, under 26G1, that's the signature rule, the party should so state. So this next slide is, I will tell you, is not a function of 40 years, 45 years of experience. It's a function of trying to bring sense to the cases that I read while I was writing the book. And what I learned was when signing responses to requests for production of documents, there's some certain rules that apply. So we start with the request for production. If responsive materials exist, then under Rule 26G, the lawyer certifies that a complete search has been done and everything is being produced. Client doesn't have to sign that because everything's being given over. On the other hand, if there are no responsive materials out there, under 26G, the lawyer has to certify that a complete search was conducted and he directed the client or she directed the client, but then the client is required to sign the response to the Rule 34 request, establishing that there are no documents. Because now that's a factual verification as opposed to a ministerial signature by the lawyer. But if there are responsive materials and there's an objection, this objection and nothing is being withheld, that's improper. Heller put a stop to that because the lawyer has to certify that a complete response or complete investigation was made. There are documents out there, but because of these specific objections, the specific ones that the rule requires, documents are being withheld and identify what those documents are. So, and that's the lawyer's signature. If these are improper boilerplate objection, the lawyer gets sanctioned. Well, how about the one, discovery is continuing? Yeah, the check's in the mail, guys. They're coming. It's coming. God, look at this. It's like I'm watching the Kirby Puckett bobblehead here. I see this all the time. Sure, discovery may be continuing, but when responding to discovery, the party and the lawyer has a duty to answer the discovery request with whatever information that they have available to them at the time. And remember, under 26G, they have to do a complete and thorough investigation. So they have to give you everything that they have available to them following a valid and thorough search. And if new information comes up in the future, then the rules require for supplementation. But it's not proper to say, well, we're working on it, we're going to get to you later. Got to give us what you got. But what if they say it's privileged? So we're circling back to it. Well, number one, Upjohn versus US makes it very clear that facts aren't privileged. Communications with a lawyer are privileged, but if there's a privilege, the party and their lawyer asserting that privilege must establish every element of that privilege. And it can only be done with an evidentiary showing based on competent evidence. And it can't be, quote, discharged by mere conclusory or ipsit dixit assertions by the lawyer. Ipsit dixit, you'll have to look up. But I think it means because I said so. Yeah, not enough. You can't say because I said so. So if it's a legitimate privilege, sure, you don't get it. But they have to assert proof that it is privileged material. So here's an example. They're required to do a privilege log. And a lot of times you'll see that privilege is asserted and no privilege log is produced. They just throw the privilege out. Doesn't count. You got to have a privilege log so the requesting lawyer in the court has a factual basis of looking at the privilege. And one of the things I encourage you to do if you get a privilege log is actually read it, because it's not just paperwork. And so in this particular case, there was an email to an insurance at West Bend Insurance Company with an attached investigation summary. And the privilege they claimed was quality assurance, like in a med mal setting where you have to have, peer review. Well, I'm thinking to myself, since when is an insurance company on an internal medical peer review? That sounds like a bogus objection. But I could argue that, but I think it's much more effective to have a record. So I happen to take the testimony of this director of nursing.
Any representative of West Bend Mutual, a member of the Lakeview Health Center Quality Assurance Committee?
No.
If anybody would represent to a court that the people at the insurance company were members of the Lakeview Health Center Quality Assurance Committee, that would be false. Is that correct?
Correct.
It's always nice to have their own witness claiming that the lawyer filed a false document with the United States District Court. It puts you in a good spot. So it's rather than arguing with them, try to build a record. If use 30B6 depositions, which is a whole other talk. But just because they claim it's privileged doesn't mean it is. So at this point, we're going to have a partner's break. I'm going to refill my tea glass, but I'll be right back. And I want to hear what the partners have, but why don't you run with this, Ginger?
Thanks,
Okay.
Mark.
Perfect. Oh my gosh, that was fantastic. And I'm getting so many wonderful messages, Mark, behind the background where everybody was asking, how can I get a copy of the slides? So just keep in mind, I will be emailing everybody watching today a copy of Mark's slides. Okay, so I'd like to first bring in one of our amazing partners. His name is Ted. You guys probably see him. Always do the copy giveaway with HMR, but he is here today to tell you guys a little bit about what they specialize in. And of course, we've been working with HMR for many years now. I love working with this company. So does John Romano. And Ted, it's actually an honor to have you with us.
Well, thanks for having me. I'm filling in. We have reps all over the place, Lanier and a bunch of other stuff going on. So I am filling in for the day. And I'm sure most of you guys have, heard about HMR at this point. We've been working with Connectionology on these webinars for more than 4 years. So we fund personal injury cases. We can provide medical funding, case cost funding, and pre-settlement funding. So depending on your needs, we can cover just about every case need or every funding need that you have. Catastrophic injuries are our specialty, but we can get involved with consults and other diagnostic needs early on as well. So we can do the full gamut. But just know that the larger injuries really are our specialty. Many funders steer away from those just because of the costs involved, and we do not shy away from those big ones. Case costs, we can do that in all 50 states, so it doesn't matter where you are, we can do it. Those can pay for expert witnesses, and it can also pay for the services of all of our great friends here at Fox AE, at Emotion Track, and On Point. We do pre-settlement funding for any living expense needs your plaintiffs may have, and then of course the medical funding, which is really our bread and butter, and that's paying for medical care that your plaintiffs may need while you're working on the case. The big takeaway is just please don't let the lack of funds, prevent you from getting the best settlement for your plaintiff. We can be there to help you. We've been doing this for, since 2012, so it's been a long time. So I will let Mark and Sam get back to it. It's always great to see you guys, and thanks for having me.
Absolutely. And then we'll have you back here in a little bit, Ted, to do the special copy giveaway, correct?
which is always my favorite part. So yes, get some caffeine
Absolutely.
away. Not tea, but it's coffee, but it's close.
Absolutely. And if you could, Ted, put your information in the chat box as well, or Kyle's. That way somebody's
Yeah,
going
I'll
to
throw
contact
Kyle's in, yeah.
in case you have any questions about HMR. But we love having you on here, so come back anytime, okay?
Sounds great. I appreciate you having me.
Absolutely. And subbing in for Cody today with Fox AE, we have Mark with us. And Mark is here to share with you guys some of the incredible stuff that they do over there. You've probably already heard about Fox AE, but they are just doing amazing things with animations, graphics, everything that you would see if you were going to trial. So Mark is going to be here and he's going to hopefully show us something like a cool video, right, Mark?
Yeah, that's what we usually do.
Awesome.
Thank you for the introduction, Ginger. Some of you already know me. My name is Mark. As she already said, I'm from Fox AE. We are a team that does graphics and illustrations for all stages of litigation. We have done it all from colorized MRIs, vehicle accidents, surgeries, slip and fall cases, all the way to huge construction cases. What I'm going to show you today is a case where a seemingly small thing caused a serious injury. On this particular case, they were creating an additional car park, and they made some mistakes in the actual construction process. Per safety regulations, an uneven surface greater than 1 inch can cause cyclists to lose control when crossing it. In this example, the average height of the exposed curb was 1 3/8 of an inch. As you can see from this shot, our plaintiff couldn't see the uneven surface from her angle of approach. While she was cycling down, she attempted to turn into the driveway, and she hit the exposed lip with her front wheel, fell forward, and broke her elbow. As you can see, there's a seemingly small lip, but that's just enough to cause you to lose control and crash. Unfortunately, in this case, the plaintiff also had a bad surgery. The surgeon impacted her ulnar nerve while doing a complete elbow replacement, causing her immense pain. Now, the tricky part is explaining what happened during the construction process. In this case, they had an approved set of plans where the exposed lip is supposed to be 1/2 inch. After the fact, they made a change in the plan, which was not approved, and now the lip is supposed to be 3/4 of an inch, so that lip height is increasing. And what they ended up building is an exposed lip that had 1 5/8 of an inch in height. Now, even with the non-approved plans and with the incorrect construction, they could have prevented the accident by simply building a temporary asphalt apron to allow any cyclist to safely cross over. That's it for me today. If you have any questions regarding how we develop these graphics, how we can help tell a good story, feel free to reach out to me. I will add my contact info in the chat. Thank you, Ginger, Sam, and Mark, and thank you everyone for listening.
Absolutely. It's amazing how those videos really share and tell the story, because being able to see it, it just makes all the difference. Sam, were you going to say something?
I was just gonna say thank you, Ted and Mark. As Aaron would say, thank y'all for helping us help people.
Mm-hmm.
Good stuff.
Absolutely. We appreciate it. And Mark, please put your information in the chat box so that way everybody can stay in touch with you as well. And I hope you come back very soon. We appreciate your time today.
Thank you.
All right. Well, Sam and Mark, back to you guys. And it's only going to keep getting better, right, Mark?
I think so, but it's
This is great,
my
great
stuff.
information.
Hey, I love that animation. I'm a cyclist. I ride 2,500 miles a year. You can get really hurt doing that stuff when people don't run the roads right. So that was good.
Absolutely.
As I'm getting ready, I just got a text from my good friend Justin Kahn, who believes I may have a miscite on the Friedland versus Middlecamp case. So he's working on getting that for us right now. And I always appreciate Justin having my back if I do a typo. So we'll see what happens. So let's keep moving here. Some of you can say, yeah, Kos, that's great. You've got all this good law, really nice, but courts hate discovery motions. They hate it. Our judges are different than all the judges everywhere else in the country. And I said, well, A, I don't think your judges are different. And B, the question is, why do they hate the discovery motions? Because remember, it was maybe 15 years ago, jury verdicts were terrible, defense verdicts everywhere, and a lot of analysis was done to rethink about why are we losing all these cases? And it became a matter of personal accountability and reframing the cases, holding wrongdoers accountable as opposed to making plaintiffs' lawyers rich. And as the cases got reframed, now we're having better and fairer verdicts than there ever have been in the history of my practice. So why don't we apply that same analysis to motions? Why do judges not like our motions? Well, because they have a preconception based on hundreds and hundreds of personal experiences. And it's children fighting in a sandbox. You can say, Mark, you're wrong. Okay, maybe they just hate you for other reasons. But the fact is, we live in a profession of bullies, and it's horrible. And everyone wants to be an alpha, and they want to be strong, and no one's going to push me around. And it gets this really hostile, belligerent stuff going on. And then you get so angry because you're spending all this time when you're on a contingent fee, and you feel like money's just going down the toilet. And it pisses you off, and you want them to pay for that. So then all of a sudden, the motions start being about sanctions instead of about getting to the truth. And I'm going to suggest to you that if you follow this protocol that I'm going to be talking about, you don't have to worry about that. And the sanctions will come eventually on their own. But the biggest sanction will be a giant verdict because you have the evidence. Because the judges, when we get in there and start fighting, think this is bullshit. These are children playing in a sandbox, and I want to deal with professionals. So our job is to neutralize that preconception. Because they start with that before you get there. Now, hopefully, if you follow this protocol, you're going to build a reputation. So all of a sudden, the judge is going to be looking forward to you coming and showing them what a professional looks like and knowing that you can be trusted. Because Nick Raleigh was just telling me at TLU a couple of weeks ago, remember that that credibility and transparency are the most important things in persuasion. And it's not just to the jurors, it's to the judge too. The judge has to believe that you are credible and that you're not playing games with them. So let's neutralize that preconception and understand that we can do it by following the rules. Because Rule 37A1 says a motion must include a certification that a movant has in good faith, bold letters, repeat, good faith, conferred or attempted to confer with a person or a party failing to make a disclosure without bringing a motion. Good faith is more than sending one email and saying, I want to talk to you, and I know you're not going to answer, so check, let's get this hurdle out of the way. Now, good faith is trying to resolve it on the law and on the merits. And if they don't want to work with you in good faith, that's just fine. You know, that's going to hurt them in the end. Hang on, I'm just seeing Justin just sent me something. Okay. So the motion needs you in good faith trying to resolve this. Because when the judge is going through the things that they have to evaluate, the real thing, the first thing they're going to ask is, have the lawyers really conferred in good faith? Have they really done that? So take it seriously. Because it's a waste of time. They never give me what I want. They're just bullies. And it's not. It's not a waste of time. A waste of time is fighting about a bunch of stuff and yelling at each other. But this conferral is hell, man. I hate it. You know, I can see people just saying, God, he's being such an idealist. I mean, I have to do Venn diagrams and charts and graphs and arrows going everywhere. And this conferral process becomes a logistical nightmare. And we've got all these emails going back and forth and back and forth. And then they misrepresent what's in the email. And then I have to clarify it. And I got 40 hours in this conferral stuff. So a lot of lawyers give up. They say it's just not worth it. And the question I ask you is, why are you asking for the evidence if you don't care if you get it? If you're asking for the evidence, that means it must be important to your case. It's not a boilerplate standard ROG. It's not a boilerplate request for documents. It's you've thought through, and I say, here are the things I need to get to the heart of the case. And if I'm going to ask for it, I'm going to be willing to fight for it. And so rather than getting into this endless game with them, don't get sucked into the vortex. It's a billing machine for them. It's happy. They don't have to think. All they have to do is throw crap at you, even if it's illegal. So I'm going to suggest to you that there's a different request protocol you can do. We start with the request for production, okay? Let's think about it. What is it you're looking for? Why is it important? How does it prove something in your case? And is this the most efficient way, proportional way of getting it? Print it, put it up on the wall, call your friends in and say, you're a defense lawyer. What's every way you're going to try to weasel out of this? And look at it. And if something is overbroad, I want every email for the last 25 years, or I want every email that the company had, or I want, data logs on things that have nothing to do with anything, but I want them anyway. Tighten it up. Work hard on making your request for production relevant and not overburdensome or have it proportional. And once you've got it tight that you know that you can stand in the courtroom, hold your head high, and tell the judge, this is why this is important. Now, don't serve it. Have it ready to serve, but don't do it. Rather, let's do a foundation 30B6 deposition. Only works if you got an organization. Not going to work on individuals. But usually the worst discovery abuse comes with organizations, and you can do the same thing by getting a lot of the information from ancillary witnesses in a non-organizational case. It's just not as streamlined. So what's a foundation 30B6? Chapter 15. We're talking about identifying sources of information, okay? We're using 30B6 to identify what documents exist and establish that they're relevant and proportional before we start, before we ask for them. We're going to neutralize all of these objections. You're going to say, how do you do that, Kaz? And that's what we're going to talk about. A 30B6 deposition is we tell the organization what we want to know, and they pick someone to be fully prepared to tell us. So what we have is a section of the 30B6 notice that's going to have some matters of examination to help us identify documents and neutralize objections. And then what we're going to do is we're going to mirror I'm just trying to get some light in here. We're going to mirror our request for a production in a schedule of documents. It's going to be just copy and paste what you're going to ask for in your RFP, but you don't ask for it. You just say, we're going to talk about these categories of documents. And what we want them to do is describe what documents exist. We don't want to ask for stuff that's not out there. Do you have policies and procedures? Okay. Do you have medical records? Okay. Does your company have an email system? Describe them. Understand what's out there so you know what you're asking for. And then ask, what's the purpose of these? Why do you have policies? Why do you have an email system? Why do you have this database? And the reason you ask that is to prove the relevance. You ask them, how is it disseminated? That's to see, is this confidential? Do they treat this stuff as confidential? And it also helps you structure on how you can look for getting stuff that's electronically disseminated. The retention and destruction policy is always good to help you identify whether there's spoliation and who's got custody of these things. You're going to find this a lot in cases involving franchises and subsidiary organizations. We had some massage envy cases where there was sexual abuse by employees on clients, and they had databases of the entire history of any one of these organizations and any one of the franchises. But what we learned through this deposition was the franchise doesn't have control of this. They can tap into a database up in the cloud, but it's in control of the mothership, of the parent corporation. And this subsidiary had no access to it. So we were able to identify where these databases were and who had them, but now we had to figure out how to get them because the mothership wouldn't give them to the franchise. But what we were able to find is, how are they organized? When you go up online to get them, How are they organized? How are they indexed? How are they filed? So you can set up, how do we find this stuff? And what are the various available search methods out there to be able to establish the most proportional way to conduct the search. So now you've got information about this. What can you ask for? What's out there? Who has it? And how do you go about getting it? And you've got all this information before you make the request. Because if you make the request, you're just going to get boilerplate objections to everything. Because now you're making a record to respond to their affidavit. Because, this is a way to get past this work product. Who's got this? Who has it? Who developed it? What was the purpose of developing it? And anticipate the objections. And you say, well, gosh, I don't know what the objections are. Sure you do. They're boilerplates, relevant, vague, overburdensome, Martians, irrelevant. You know what they all are. Just assume the boilerplates and do this really tricky question. Is it relevant? Is it vague? Is it overburdensome? Just ask them. I don't know why we always have to think about how we're going to trick them. Because you ask them. Say, what do you mean?
So, when I use the term resident census, what do you think that means?
The number of patients in the facility.
Is this a term that you use in the daily operation of your nursing home?
Of course.
Is there anything ambiguous about the term resident census to you?
No.
Resident census data is kept in your computer, right?
Yes.
You look it up every day? Is there anything hard about looking up that data?
No.
You just call it up on your computer, right?
Yes.
How long does it take?
A couple of seconds.
Is it burdensome for you to call up that information on the computer?
No.
Can you print it?
Yes.
How hard is it to print?
You hit the print button with the mouse.
I'm going to hit the print button with the mouse. Believe it or not, even with that testimony, when I made the request, we got the objections. Vague, irrelevant, overburdensome, not calculated to lead to admissible evidence, even though their own 30B6 designee said all of that information was false. Because the lawyer didn't even think about it. It just used a knee-jerk reaction. So consider taking these depositions to neutralize the objections before the RFP, before you serve it. And now that you've got all this stuff, now you serve the request for production. And what's going to happen? You're going to get the bogus objections. So what do we do? I mean, it's a nightmare. Well, we got to organize them, and we can use that very, unique, out there software, Excel, that's on every computer that who's on this program, and probably on most of your telephones. And what we do is we create a table of deficiencies in Excel, and it's got a number of columns. And the first one is, what is the actual discovery request? The interrogatory or the document request, each individual one. And then, why is it relevant? And you should be able to say why it's relevant in a sentence or two. I suggest you create this table of deficiency before you even serve the interrogatories or document requests. And the reason for that is, when you're writing the relevance, sometimes you may find you can't articulate it. And then you're going to be pretty red in the face. If you can't say why it's relevant in a sentence or two, the judge is probably going to say it's not relevant. So think about your request and get it ready. But now you have the next column for objections, and you got a line for every single objection for the request. So if there are boilerplate objections, each request might have 10 or 12 objections. The next column is, what is the legal deficiency of that objection. If they say overburdensome, it's a assertion of overburdensome without any factual basis supporting it. Or if they say vague, says assertion of vagueness without any attempt to clarify. But there's legal principles to that. Or you have the 30B6 testimony. But then your next columns are opportunity to withdraw the objection or for the judge to check overruled or sustained. So now everything is in a spreadsheet. And it'll track the objections. And when you see the same objections over and over and over and over again, the boilerplate nature of them jumps off the page. And you populate the legal deficiencies in that spreadsheet. Unfounded objection must produce a privilege log if it really believes the documents are privileged. If they say it's exceeds the number of objections you can make, it's a burden on them to say what you can do. You just put in what's wrong with it, and also put in the 30B6 testimony. Objection vague. Copy and paste from your transcript. Is there anything ambiguous about the term resident census to you? No. 30B6 designee, page 27, lines 3 through 4. Now, if you've done this methodically, on each request, you've read the request into the deposition and asked them to talk about it. So now you just word search your request. Yes, people over 50, you can word search a deposition. You don't need to have an index in the back. You word search it, and because it's digital, if you've asked tight questions, copy, paste into the spreadsheet. This doesn't take long. It's easy. And now that you've populated the spreadsheet, you can meet and confer. Take it seriously. You really can. This is, if you take it seriously, the court will take it seriously. So start with a nice deficiency email that's very polite. Dear Tom, this is, excuse me, this is my first step in the meet and confer process about my concerns about the objections that were without a factual or legal record. Here are the legal principles for it, and I've attached a table of deficiencies that I'm going to use as the roadmap for us to walk through these objections. Now, some of these look like they're boilerplates, respectfully. So before we spend time meeting, why don't you take a look at this spreadsheet and see how many of these objections you want to stand by? And if you do, then we're going to go through them factually and legally for each one. And so we're going to, and I've also attached the law for you. And if I got the law wrong, let me know, because we should be talking about the same page on the law. And you show the table of deficiencies. You show the 30B6 testimony. I suggest you could even share a draft of a brief that you already have roughed out and say, here's the law I have. Why don't you take a look at it and tell me if I got the law wrong, so we're all on the same page. They get this and go, oh man, we're not in Kansas anymore. This is, these guys are serious. And this is where we use that radical tool, the telephone. We're not texting. We've sent the preliminary email, but you call them up and talk. Have a conversation. Some jurisdictions actually require it. I just say it's good practice. And actually, since we've been through the plague, we can now Zoom. We can face-to-face. But the next thing I suggest as you're going through this spreadsheet and Zooming and talking is meet for coffee. You can say, what? What? I'd rather have surgery than do that. Hang with me, and in a moment, you're going to see why that is important. because you've talked to them and you've got the column giving them the opportunity to withdraw their objections, to check them off. And, and then you send them a stipulation to withdraw the objections with the spreadsheet. Because if they won't sign the stipulation, they're not really withdrawing them. Well, I'm going to send you an email. No, let's have something that we can give to the court. What's being withdrawn? And what if they're still going to object, Mark? Fine. We're going to let someone else decide. When I was younger, I said, do this or I'm going to bring a motion, threat. Now it's I want to work with you on the law and the facts. And if we can't come to an agreement, we'll let someone else decide. And that's where you get the ruling on the spurious objections. And this is where you show the judge you're a professional. You show them that you're not a child that's been fighting in the sandbox looking to hurt your adversary. You're trying to get evidence that's relevant. And so you have to give the judge a solid confirmant affidavit. Shuffle Master versus Progressive Games. It's the seminal case on conferral. And there are cases out there all over on it, but this is the big one. And it says a simple cursory statement in an affidavit is not enough. Say, we met, we were unable to resolve this, which is what I did for 30 years. So don't feel bad if that's what you're doing. But that's not what the courts want, because they want a serious conferral. The affidavit should include the names of the people who conferred. When did they confer? What was the manner? Telephone, email, text, Zoom, coffee. What were the things that were talked about? When did it occur? How much time did you spend? And what were the results? People are saying, God, I'm shaking my head on this one, Kaz. This is awful. But I don't keep time, but we have this spreadsheet we use that we just, for any conferral, we have the spreadsheet that has everything that Shuffle Master has. And you're talking on the phone or sending an email and you just fill it out. But now you've got this conferral log that has the names, who did it, what you talked about, and you have the check marks on the spreadsheet to show what the results were. So you don't have to have 40-page emails summarizing what was done. I'm going to tell you, I had a lawyer talk about using this in North Carolina last year, and the lawyer said they went from 308 objections to 6 because the lawyers were afraid to put all that nonsense in front of the judge. We had a case in our office just 2 months ago where once we did this, the general counsel of the defendant decided to hire a new law firm. They didn't want to respond, and we said, well, we're not going to delay our conferral. And I said, no, but we're going to have other people working on this. And we got the things resolved because now you have the conferral affidavit that you send to the judge, not saying these guys are A's, they're asses. We can't get along. I want to hurt them. I want sanction. No, you say counsel have worked together diligently and professionally. We've shared authority. We've exchanged 14 emails. We've spoken 4 times. We even met for lunch. And we were able to resolve 82 objections, and we respectfully request the court's assistance on resolving the 17 remaining legal issues. I've yet to see a judge be angry when a motion came, when you get an email like that, saying, how refreshing, because now you're compared to all the jerks. And you're saying, God, this is an adult. This is a professional. And we had the judge say, it's an honor to work with lawyers like you. It'll be my privilege to answer these questions. So what we do is we also give the time record so they see all the time we spent. Say, well, I don't want to spend that much time. Well, you're going to have to, and you think that takes time. Wait till it comes writing the brief and the 25 or 30 emails. These conferences don't take long. The spreadsheet really, really works. So with that, you give it to the judge. You can embed the spreadsheet in the order if you want. And all the judge has to do is check overruled, 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 overruled. Because they see all the arguments. Because what we do is we have a brief that's like 12 pages long that has one paragraph for each legal principle, not a tome with all the cases cited in the book, but the sentinel case or the case in the jurisdiction we're in. The spreadsheet has the factual arguments, and you link the two. In the brief, so here's the law of vague. Defendant has asserted vague to answers 1, 2, 3, 4, 5, 6, 7, 8, 9, and 10. In the spreadsheet, wherever it says vague, in that area where you say there's a deficiency, say, here's the takeaway of the law, see section 1 of plaintiff's brief. And with that, we have checkmate. Now, if you want to streamline this, there's a litigation package at AAJ called the Stonewalling Solutions. It's got the software, which is really nothing more than a template for an Access database that comes with a Microsoft package. And it's just a form, and you fill out the forms, and you put in those columns, and you just click the buttons, and it automatically self-populates this entire spreadsheet for you. And then it has the notices, all the emails that go back and forth, the timesheet, the stipulation to the withdraw objections, and the template brief, and request for sanctions, and the order, and the time conferral. So that can streamline everything, but you can do it all manually if you want. You just have to set it up. And what I was told this morning is AAJ is going to bundle the Stonewalling Solution litigation package with the book. And you know, the Stonewalling Solution is pretty expensive. It's like $500. And the book's 170, and it's got all the information except for the software. But what they said is they're going to knock $300 off, so the whole thing is less than the Stonewalling Solution to start with. So if you're interested in it, this is a QR code. If you're interested in the book, I think it's the most important book I've written, probably the last book I'm writing. And as you're moving forward with all of these problems, I think it's important to remember that whenever you analyze anything, it always goes back to the blues. Thank you, my friends. It was a privilege talking to you. I assume we're going to have some questions. This took a lot longer than we thought, but here we go.
Man, Mark, that was great. Thank you so much. I am at least 10 IQ points smarter now. That was awesome. So we do have some questions lined up, and guys, keep posting your questions if you have any.
Okay.
But the first question is there a continual fee for the Stonewalling Solutions software, or is it just a one fee and you got it deal?
Here's how it works. It's a template. You use the Access database. It's a template. So you have to copy the template, and you can just use it over and over and over again. If you don't copy it, then you got to purge it. So it would have cost about $20,000 to make it so you can do just pay for it every time you use it online. And, I just did it for our firm, and AAJ asked if they could sell it, so they can make their money. If you buy all of the documents for the Stonewall solution are in the appendix of the book. But in this bundle, they said they'll give it to you in Word. So now you've got it.
Gotcha. Okay, thank you. Another question here is that with the limitation on depositions, 30B6 depots, is there an issue of getting a second bite at the apple between doing the foundational 30B6 depot versus and still getting to do the substantive depot?
That is chapter 4 of the 30B6, Deposing Organizations, Corporations, and the Government. It's a different book that's published through Trial Guides. The short answer is judges can do anything they want. Okay. They set their scheduling orders. There's 2 lines of cases, one that says you only get 1 deposition, another says one 30B6 deposition, another line of cases you can say you can take as many as you want. And aside off of that line of cases is they say because it's one party, different notices on different subject matters are all considered as one. What we have found to be most effective is to craft your foundation 30B6 deposition notice and craft a second substantive one. And in my cases, sometimes we have to do a corporate structure, which is a third one, because who's got the info. And then we have to do in our state, similar to the federal rules, have a Rule 26 scheduling conference or meeting for the Rule 16 scheduling conference with the judge. And we just give them those notices and say, these are the people we want to depose, and these are the different topics, and we want to phase them because we don't want to ask for things in our RFP that don't exist. We want to do the corporate structure because we want to go to the right parties. And then once we get all the documents in the ESI, then we'll do the substantive. I've never had a judge say you can't do a foundation and a substantive. I've had some judges limit us to the 2. I have other defense lawyers saying, fine, this isn't a battle worth fighting. Chapter 4 of 30B6 from Trial Guides has the case law throughout the country at the time that book was written, which was 5 years ago now.
Okay. Looks like maybe the last question we have here so far is some states, before you file your motion to compel, they make you file a joint Rule 26 statement, limited to a number of pages. So the question really is, how do you get around it if you can at all?
Well, I don't think that's a workaround. I think what you have is you do this meet and confer process, and your half of that joint letter will just summarize where you're at. You've got it summarized. You do that. We've met and conferred. We've reduced it to these number of questions. Here are the legal questions we have, and they said, and we have an available spreadsheet for the judge of all the objections. But what you have with that spreadsheet is a summary of the law and a summary of everything you've done. And typically we get down to about 8 issues. And when I wrote the brief for the Stonewall solution, we've tried to limit any legal principle to 2 paragraphs. And you can limit it to even more because they kind of repeat themselves. So everywhere I go, we have to do that letter. And I don't view that as a workaround. I just view it as that's just one more step in here and gives us one more opportunity to show the judge. I mean, when you put that beginning, we've worked together diligently and professionally, and we've met all these times, and you've burned up 3 sentences doing that. You've already got the judge thinking, okay, this is different.
Yep. Okay. Mark, that's all the questions we have, and it was great. I loved it.
Well, thank you so much. It was so fun meeting you, Sam, and I look forward to the next time I'm in Arkansas, maybe even at the ranch, and getting to know you there. Congratulations on that killer verdict you just had for first one out of the gate.
Yes, sir. Thank you.
Absolutely. And I cannot thank you guys enough for being a part of this today. Absolutely incredible. If everyone gives me a little bit of time, I'm going to send you a copy of Mark's slides, as well as his contact information. You can stay in touch with Mark, with Sam, and all of our amazing partners that you guys met today. And I am going to pop their contact information on the screen real fast. So you're welcome to take a picture of this and save it, but just know that I am going to email this to you as well, so you can follow up with any questions that you have and stay in touch with them. And then I'm also going to email you the information for Mark's brand new book in case you guys would like to purchase that through AAJ. But it's definitely must read. I tell you, the 30B6 is the one you definitely should already have in your office, but this is the one you're going to want now. So hope you'll get a chance to check that out. And then, like I said, follow up with Mark if you got any questions. And then also, as you guys see, we've got Ted back with HMR. So that means you know what time it is, right, Ted?
It is coffee time.
It sure is.
Coffee?
Yes. So one lucky winner is going to win 4 bags of this freshly roasted.
I thought saying 4 o'clock is coffee time after a program.
It probably is coffee time for all of us, wherever we are in the country right now. Iced coffee here in Florida for sure. But Ted, it is great having you with us to do this special copy giveaway. And also, you guys, don't forget, next week, I'm doing another webinar on Tuesday and Thursday at 3 o'clock Eastern time. I'll have those up on the website tonight, so you can take a look at what we're doing next week. But anyway, Ted, take it away. I'm gonna go ahead and hand that over to you so you can announce the winner.
Yeah, sure. So it's a wonderful webinar today. So thank you both for your great presentation. I am excited to announce our winner today is John Wynn. I really wanted to say Wayne, but it's John Wynn. And he's out of St. Louis, Missouri. So congratulations on some fantastic coffee.
I wonder if he does get that a lot.
Yeah, I bet.
You never know. But John, congratulations. And again, thank you so much, Ted, for offering this amazing giveaway. We'll reach out to John in a few moments to make sure that he gets that. And again, don't worry, if you didn't win this time, there's always a chance next week. Ted, I think you've given away thousands of coffee to people across the country. And we thank you for that.
Was that good coffee?
It is good coffee, yeah.
Sure is. All right. Well, thanks, guys, for joining us today. Keep an eye on your emails from me. And then Mark and Sam, do you guys have any closing comments before we head out?
Thank you for inviting me to speak at this program. The biggest thing that I've tried to do is empower everybody. The book is just, that's helps you get the stuff. But don't let the bullies push you around. You've got the rules on your side. Don't get into a fight. Just say, we'll let someone else decide and trust the system. And, we're not playing hockey. We're not going to win 1-0. It's more like basketball, 78-72. But if you take this high ground approach, you're going to win a lot more than you're going to lose.
Mm-hmm. Absolutely. Well, thank you so much, Mark. And Sam, we're going to see both of you guys here again soon on another webinar, because I know there's a lot more that you'd like to teach everybody. And again, if anyone watching today has a great topic, please reach out to me and we can get that scheduled for you to do and speak on a webinar later this year as well. Ted, see you soon. All right. Bye, everybody.
Have a great one.
And thank you again so much, you guys, for these amazing comments that are coming in. In case I didn't get a chance to read them all off, just email Mark and Sam. All right, guys. See you later.
Bye.
Until next time.